All right, let's jump right into it. Today, in this explainer, we are unpacking a legal battle that has the entire tech and publishing world absolutely on the edge of their seats. We're dissecting the historic Anthropic copyright lawsuit and, honestly, its pretty shocking conclusion. What we're really looking at here is a massive, head-on collision between cutting-edge AI technology and traditional, old-school copyright law. And the results of this clash, well, they are truly fascinating for anyone who creates or even just consumes digital content today. $1.5 billion. You heard that right, billion with a B. We're looking at a staggering $1.5 billion class action settlement, which actually just received final approval from federal judge Araceli Martinez-Olgan. This puts an official legal stamp on the whole agreement. You know, this isn't just some minor regulatory fine or a little slap on the wrist for a tech company. It is a monumental forced transfer of wealth from an AI powerhouse directly to the creators whose works allegedly fueled their AI models in the first place. The sheer gravity of that number really cannot be overstated. And to put that massive figure into proper historical perspective, this landmark payout is widely believed to be the single largest settlement in the entire history of U.S. copyright law. Think about all those intense copyright disputes we've seen over the years: music pirating, movie bootlegs, software piracy, you name it. This single AI settlement completely dwarfs all of them combined. It sets this towering financial high-water mark, and trust me, the rest of the technology sector is paying very, very close attention right now. Let's actually break down the math here so we can wrap our heads around the true scale of this. The payout essentially delivers $3,000 per individual work, spread across an estimated 500,000 works. These funds are going to be shared by the rights-holding authors and the publishers who brought the suit. When you think about it like that, you can truly grasp the staggering volume of data used to train these models. Imagine 500,000 individual books, articles, or essays, with each one commanding a $3,000 piece of this historic pie. It's a phenomenally vast operation. Which brings us to Section 2, the plot twist, why creators aren't celebrating. Now, here's the massive plot twist to the whole story. There is this clear, honestly jarring paradox between this historic financial windfall and the deep disappointment felt by the very creators who sued. You'd reasonably assume a $1.5 billion settlement would have authors and publishers popping champagne, right? Well, not exactly. Despite the massive checks being cut, a lot of creators do not view this as a win whatsoever. For them, the money simply doesn't fix the underlying problem they were trying to address in the first place. To figure out why they're so frustrated, we have to look at Section 3, the legal nuance, training versus acquiring. Okay, so to understand exactly why creators are so upset, we have to look closely at how retired Judge William Alsup resolved the core legal questions right before he stepped down. He actually sided with Anthropic on the absolute core issue at the heart of this entire debate. He ruled that the act of training an AI model on copyrighted text is legally considered fair use. Let that sink in for a second. The actual ingestion, the reading, the learning process by the AI was deemed legally acceptable. So for authors, this felt like the court validating the exact practice they were fighting against. So the absolutely crucial takeaway here is that this specific fair use decision was widely seen as a massive victory, a total turning point for the entire AI industry. The publishers originally wanted the court to declare that training an AI on their books was inherent theft. But instead, the judge basically established that the learning part, the AI just analyzing the text, is completely fine. And honestly, this was exactly the legal validation that AI developers across the globe had been hoping and waiting for. But that wasn't the end of the story. That brings us to Section 4, the pirate site loophole. How Anthropic got caught. See, while the training itself was deemed fair use, the ruling did absolutely nothing to excuse how Anthropic actually got their hands on those millions of books in the first place. This perfectly illustrates the divide in the judge's logic. Anthropic built its library from two distinct sources. Source number one, books they legitimately purchased and scanned. The judge ruled that was perfectly fine. But source number two consisted of books downloaded directly from known pirate sites, like Library Genesis and Pirate Library Mirror. The judge found this second method to be completely, unequivocally illegal. Because the judge said that specific piracy question could go to a jury trial, Anthropic suddenly found itself in a really precarious position. So they quickly agreed to this massive $1.5 billion settlement to avoid whatever unpredictable and potentially catastrophic damages a jury might have awarded just for the piracy aspect. Juries, as you might know, can be absolute wildcards. They often lack deep technical literacy and can be easily swayed, especially when blatant pirate sites are involved. Anthropic clearly decided it was infinitely safer to just write a historic check rather than roll the dice in open court. This calculated settlement leads directly into our next topic, Section 5, the unsettled legal precedent, a strategic dodge. Because Judge Alsup's fair use ruling was just a single district court decision, Anthropic's choice to settle at this exact moment is a highly strategic, almost sneaky maneuver. By settling right before an appeal, it means this case will never reach an appeals court. And because it never reaches that higher court, this ruling will never become binding precedent industry-wide. It remains just one judge's opinion in one single district. The overarching legal rulebook hasn't actually been rewritten for everyone else. It was a brilliant dodge to protect the industry from a broader ruling. And because the rulebook wasn't ultimately rewritten, the broader battle rages on in Section 6, the ongoing AI copyright war. The fight isn't over. This crucial lack of binding precedent means other judges across the country are completely free to reach their own conclusions based on their own unique sets of facts. And that is exactly why there's still a massive, ongoing string of copyright lawsuits against other tech giants. Heavyweights like Google, Meta, Midjourney, and OpenAI are all currently fighting similar battles in court right now to determine if training AI on copyrighted works is actually legal. The Anthropic settlement didn't end the war, folks. It just closed down one single battlefield. To show you just how active, urgent, and unresolved this entire landscape is, we don't even have to look back very far. Just last week, a brand new class action lawsuit was filed accusing Google of using copyrighted works to train its incredibly powerful AI platform, Gemini. It's the exact same fundamental argument, but with a brand new defendant and, crucially, a completely different judge who might interpret the whole fair use argument entirely differently than Judge Alsup did. And the plaintiffs taking on Google? They are not small players by any stretch of the imagination. We're talking about a powerhouse coalition of major educational and commercial publishers like Hachette, Cengage, and Elsevier, acting alongside prominent authors like Scott Turow and the organization SCRIBE. These are entities with massive financial backing and enormous commercial interest to protect. They're gearing up for a brutal legal showdown, hoping to force a different, legally binding ruling on that crucial fair use question. So, as we wrap up this explainer, the Anthropic settlement leaves us with a billion-dollar question to ponder. If the act of training AI is ultimately protected as fair use, but acquiring the data remains a total legal minefield, who really owns the future of digital content? It's a massive, complex puzzle, and as we've seen from the ongoing lawsuits, the industry is far from finding a definitive answer. Thank you so much for joining me to explore this. Keep your eyes peeled because this digital frontier is only going to get more interesting.